This podcast is being brought to you by Trinity College Dublin. For further information, please visit our website itunes.tcd.ie.
Could I please have your best attention? As you know, the context of our invitation this afternoon is the fact that we have been studying, with the help of Dr. Elaine Byrne and Mr. Shane O'Minican and others, the issue of the relationship between political culture in this country, problems of corruption and governance. Now, needless to say, I don't have to tell any of you that the backdrop to all of this is the report of the Moriarty Tribunal and what it has to say about the practice of politics in this country. I am really grateful to Minister Pat Rabbitte for coming in here this afternoon. Today is a very important day in Irish political and economic life, as you know, with the stress tests and the announcements that are going to be made in a very short time. But also, Minister Rabbitte has been very much involved in the last number of days with responses to the Moriarty Tribunal report. I would first of all remind you that Minister Rabbitte is a guest. He's here on my invitation. We all have different perspectives, but we must express them with courtesy, respect, and of course the welcome that we owe anyone who comes in to talk to us. I'm very grateful for Minister Rabbitte coming in here this afternoon, and I ask you to welcome him.
Thank you very much indeed, Jacqueline, and thank you for asking the audience not to throw anything at me while I'm here. So let me start by being provocative. And supposing I was to start by telling you what I do not believe. I was looking at the preparatory material that Jackie sent me for this event, and as you probably know, I was supposed to be here on a different occasion, but I was waylaid by business in the Dáil. And that was a presentation from Dr. Elaine Byrne, headed Corruption, a New Definition. And I found it very useful in terms of my trying to plot what I was going to say to you. The presentation dealt firstly with the traditional legal definition, highlighted manifest inadequacies and considered alternatives. It examined particular examples and asked whether they should fall within a definition of what is called legal corruption. Should undue, but not illegal, influence by vested interests over regulation, for example, or policy making, be considered a form of corruption? And that's really the net point that I took from that. One topical example comes from the report of the governor of the central bank into the causes of the banking crisis. And he wrote that significant factors contributing to the unsustainable structure of spending in the Irish economy were due, and allow me quote him, the government's pro-cyclical fiscal policy stance, budgetary measures aimed at boosting the construction sector, and a relaxed approach to the growing reliance on construction and other insecure sources of revenue. Now, that judgment is, of course, at the heart of the modern-day political debate in this country on the causes of the greatest financial crisis in our history and on our attempts to resolve that crisis. But I believe that it's a devaluation of words to describe that judgment of Professor Honohan as having anything whatsoever to do with corruption in Irish life. Poor decision-making, informed by short-term, shoddy and self-serving policy analysis, can lead to catastrophic results. But the corruptness, if I may use that term, the corruptness of an action is not measured by the scale of the disaster that it produces. Nor by the same token is there a great deal of evidence that bankers, as opposed to policymakers, were driven by corrupt motives. To a large extent, remember, these same bankers were the same people who believed so much in their own spin and in their own propaganda that up to the very end, they were still investing their own money, as well as borrowed money, in the shares that their own actions were about to make worthless. Does a corrupt individual do that? A corrupt individual tries to make money from his wrongdoing, not put his own money on the hazard and destroy his own wealth. There are a range of items on the reform agenda falling under the heading of openness, transparency and accountability, a phrase adopted by the Labour Party back in 1992, which we have been pursuing ever since. But I repeat my own belief that it adds nothing to the debate to throw the term corruption around too casually, as if it applies to all phenomena falling short of model standards of open and accountable government. In particular, the fact that decision makers make concessions to vested interests is a fact of life and of every walk of life. Fianna Fáil's support, for example, for the construction sector and the property sector generally is well known. And the party did receive financial rewards. But I have no doubt that most decision makers in that party believed in the win-win scenario, that what was good for construction was good for the country, and it was great that it happened also to be good for the party. Now, you can disagree with their attitude, but you can't describe it as corrupt just because you disagree, any more than you could say that it was corrupt for a Labour Party minister to introduce May Day as a public holiday, or to permit tax breaks for trade union subscriptions. The fact is that politics is all about receiving and considering the submissions of interest groups and deciding between them. Every day of the week, government makes decisions that confers wealth on some people or impedes wealth aggregation by some other individuals. That's the nature of the political system. The very fact that we have different political parties is a reflection of the fact that different politicians are amenable to receiving different arguments based on considering the wants and the needs of different groups, and different politicians will react differently. But I'm very reluctant to say, and I'm not taken as read here, that you are all aware of the fact that we've had a number of spectacular instances of corruption in this society. But because ministers or because politicians react differently to different interest groups doesn't automatically mean that they're corrupt. It can mean that, or a particular decision they make can mean that, but it can't automatically be a conclusion drawn. No matter how open our system of government may become, there will always be value judgments to be made, based on an assessment as to the impact of our decisions on the interest groups affected. In the reform agenda, the defining feature of corruption is that it is a crime. It can be punished by an unlimited fine or by up to 10 years in prison. The other important feature of this offence is worth remembering. Corruption is not confined to public office or public administration. It is just as capable of being committed in the private sector. Company directors and executives, the executors of wills, travelling salesmen, and even university lecturers are all covered by the same set of laws as government ministers and heads of semi-state companies. It is perhaps a measure of the knee-jerk level of public debate on the issue that we hear so little debate on corruption in private as opposed to public life, or even look for the evidence of it. The Transparency International Corruption Perceptions Index assesses public attitudes to corruption in the media, business, the law and policing, as well as in political life. But perceptions in relation to those other sectors receive very little scrutiny or public debate. Personally, I do not believe that politics here is any more corrupt than in any of those other sectors. Politicians thrown up are products of this society and products of this uniquely Irish culture. The implication behind the title of this session is that the political system and corruption somehow go hand in hand, or at least to a greater extent than business and corruption. They do not. Nor is our system of politics to blame for the mess we're in. Responsibility for the depth of the crisis we're in rests squarely with traceable decisions of government that preceded the crash. It is necessary to say this because blaming the political system and identifying systemic failures has, I believe, become the new version of "sure you're all the same." And the "sure you're all the same" school may be correct. And this is the first opportunity in some years to find out. Because, as you know, the Irish people have elected the same party to lead government since 1987. The Rainbow government of 1994-97 happened by way of parliamentary accident. Other than that, one party has established a hegemony over every level of this society for more than a generation. Now, I want to make the simple, unchallengeable point that dereliction of duty by parties in government is separate from either systemic weaknesses in the political system on the one hand, or imputations of corrupt motive on the other. Wrong decisions and a propensity to avoid decisions for reasons of self-serving cronyism in the years preceding the crash have made our crisis so much worse. But wrong decisions by government should not be either conveniently filed away under defects of the political system or classed as the actions of white-collar criminals. I have a lot, and I have many differences with my colleagues in Dáil Éireann who preceded me. Well, a lot of them aren't there now, who were ministers in recent governments. But I would not describe them as political, as white-collar criminals. May I say now that where I do agree with Elaine Byrne is that the difficulty about corruption is that it is both consensual and secretive. As a result, it's very hard to prove. The reform agenda is as much to do with making it more difficult to commit the offence as it is to do with changing the definition of the offence. The legislation has a very long history to it. The original 1889 Act applied only to public and local bodies outside of central government, as if there could be no corruption at the heart of politics. The 1906 Act introduced a comprehensive measure to deal with corrupt transactions, both private and public, by a third party with an agent in relation to the affairs of business or business of that agent's principal. This is still the modern essence of the offence, financially or otherwise inducing or rewarding an agent to betray the interests of his principal in favour of the interests of a third party. Those holding office under the Crown were deemed to be agents of the Crown. Members of Parliament, however, as opposed to ministers, were not considered to hold office under the Crown and so were not covered in that capacity. In 1916, a presumption of corrupt payment was introduced to cover situations where it was proven that a payment was made by a person holding or seeking a government contract. In other words, if a businessman who had or was looking for a contract with, say, the Minister for Munitions, made a gift to that minister, those facts alone, without further proof, would give rise to the presumption that the gift was corruptly made. That's a pretty high standard. In 1995, the Rainbow government took the opportunity of passing the Ethics in Public Office Act to update the language of the Prevention of Corruption Acts and to introduce a comprehensive definition of a public body to which the acts would apply. My colleague, Brendan Howlin, introduced a further reforming and consolidating measure in the year 2000. The government published a bill at the same time. Labour's bill included a provision creating a presumption that could be used in criminal proceedings. Under the Labour bill, there would have been a presumption that money had been corruptly received if it was proved simply that an office holder had received money and that the donor was a person who had an interest in the office holder's performance of his or her functions. The presumption was no longer confined to cases where the donor was looking to a government contract. It could be a grant, a licence, or maybe a change in the law. The Minister of the day, John O'Donoghue, replied, if I may quote him, the problem, he said, is that there may not be a clear, he opposed the bill. And his reasoning was, the problem is that there may not be a clear connection between the giving of the money and the performance or failure to perform official functions. In addition, a wide presumption, as is suggested, involving a general reversal of the presumption of innocence, raises constitutional and European Convention of Human Rights implications. Indeed, on one interpretation of this type of provision, it amounts to a presumption of guilt in the circumstances outlined. However, it's worth noting that by the time the bill was passed into law, those legal and constitutional difficulties had somehow disappeared, and the legislation as passed included the presumption as suggested. The law was further strengthened in 2010, and the programme for the new government, the present government, commits to further reform. The law as it stands is quite robust, in my opinion. Its merits cannot be tested by the number of convictions achieved, which remain a handful, including one just yesterday. The criminal law will never be the principal means of confronting and defeating the phenomenon simply because evidence of secret collusion is, as Dr. Byrne says, so hard to obtain. Nonetheless, the law is now underpinned by two quite powerful presumptions, both of which were proposed by my own party. First, as I've said, any financial transaction with an office holder from someone who has an interest in the outcome of the performance of that office holder, of his functions or her functions, is now presumed to be corrupt unless and until the contrary is proven. Second, any political donation that either exceeds the legally acceptable limit or exceeds the disclosure threshold, but was not disclosed, can now also be deemed to have been a corrupt payment. I'm not sure how much further that we can go in making use of evidential presumptions to strengthen the criminal law. Unless, perhaps, we adopt the provisions I believe operate in Singapore, where it's an offence for an official to maintain a lifestyle beyond his income. The criminal law is only part of the response, and I think that's important that we keep that in perspective. There is much more to the reform agenda. And I would stress that the reform agenda is not entirely or even principally motivated by an anti-corruption drive. We support freedom of information, to take an example, not because it makes corrupt practices more difficult, but because we're convinced it leads to better consideration of the issues, better decision-making, and therefore better government. The reform agenda featured in the manifestos of both Fine Gael and Labour, both in the last election and in 2007, inevitably, given our present circumstances, it featured much more prominently in debate this time around, not just in the media, but also in the doorsteps, and that was because the election was being held against a particular backdrop. The programme for government now contents itself with name-checking most of our proposals because by now they're very familiar. Although I'm not convinced that corporations enjoy constitutional rights, when it comes to political activity, we are told that a previous Attorney General advised there were constitutional difficulties in abolishing corporate donations. We are therefore committed to introducing and taking whatever steps are necessary, be they legal or constitutional, to ban corporate donations to political parties. And if there are grounds to support the argument that there is a constitutional impediment in the way of doing that, well then we will have to have an amendment to the Constitution by way of referendum. This legislation is now being prioritised and it should be published before the summer. So far as personal donations are concerned, we've committed ourselves to reducing the limits on donations to political parties and candidates and to requiring disclosure of all aggregate sums above that limited threshold. As the author, on behalf of the Labour Party, of the original registration of lobbyists and whistleblowers protection bills, I'm particularly pleased that the government has promised to introduce a statutory register of lobbyists in addition to a set of rules governing the practice of lobbying and to introduce legislation to protect whistleblowers. We have promised to return freedom of information legislation to the state it was in prior to the 2003 Act, which some people, at least, believe was designed to spancel the operation of the original Act introduced by my colleague Ethna Fitzgerald. Of perhaps less immediate relevance, we will amend the Official Secrets Act, retaining a criminal sanction, but only for breaches that involve a serious threat to the vital interests of the state. We have promised to scrap the current restrictions on the nature and extent of evidence by civil servants to Oireachtas committees and to replace them with new guidelines that reflect the reality of the authority delegated to them and their personal accountability for the way it is exercised. With regard to the relationship between civil servants and ministers, we need to introduce reforms that reflect the transformation that has taken place in this relationship. And we're committed to holding a referendum to reverse the effects of the Abilara judgment and thus enable Oireachtas committees to carry out full investigations. Considered institutional reform is necessary and urgent. I fully understand the impulse to lash out at the political system and its inhabitants when so many of our people have been deprived of their livelihoods, when some face the loss of their homes, and when a new generation face the challenge of forced immigration. There is no denying that homegrown decision-making has contributed enormously to the depth of the crisis we're in. Therefore, our political system has not provided the protection that could reasonably be expected by our citizens. Corrupt actions are undoubtedly involved at some level and scale, but not, I think, predominantly. And our political architecture bears a share of the responsibility for the crisis. But it may be difficult to persuade people which is the best way to go to reform that. But you cannot rule out the reality that the system always presented choices to the electorate, and those who caused our crisis did so with a mandate from the people. Politics is ultimately a contest between competing candidates, parties, and programmes. I've been on the losing side in more than enough of those competitions. I believe I'm more than competent to critique my fellow contestants, but I think it's a bit of a cop-out to class those who have defeated me over the years as beneficiaries of a defective political system, let alone one that is systematically corrupt. The choice is between blaming the system and dismissing it as hopeless, inadequate and corrupt, or tugging out and playing to win, and having won, to change the rules. Thank you very much.
Minister Rabbitte is happy to take questions. Thank you very much. And we'll use the usual system. If you speak them out, and I'll use the microphone so that he can hear them. Okay? Okay, up there, yeah?
You said that specific problems in the Irish political architecture are partly responsible for the current crisis. Could you give an example of this, please?
That question relates to the architecture of our government and political system, and the questioner is looking for examples of that.
Well, I suppose there are a number of examples. For example, over the last 20 years, more and more the executive has arrogated to itself powers at the expense of Parliament. And really, the independent existence of Parliament on occasion is even questionable. The last occasion that I can recall in which Parliament asserted itself was in the Dirt inquiry, when, while examining issues of tax evasion and retrieving just in excess of €1 billion for the Exchequer, the inquiry was conducted in public, on live television. Citizens and taxpayers were able to judge for themselves the fairness of the procedure. They were able to make their own judgments about the demeanour of the witnesses. And a conclusion was reached in a very short period, well, very short by comparison to tribunals of inquiry, and at minimal cost. And it's an example, only one example, but an example of Parliament having its own independent existence and asserting it.
The question relates to trade union and corporation donations to political parties and the difference between them.
Well, I'm not sure that there is a difference. It would be insulting to the trade union movement to describe them as a corporation, because they're not. But in terms of what we're talking about here, I'm not sure there is much of a difference. It's a donation. It's from a large organisation. So is a typical small and medium enterprise for this purpose, that much different? I don't think it is. There's a historical explanation in terms of the support that some of the trade unions give the Labour Party, which is that there's an organic link there, given that the Labour Party in 1912 was born out of the trade union movement and has maintained, or some unions have maintained, that connection ever since. But my own view is that the legislation that we will publish will include a disbarment on the unions as well as corporations. Well, I don't know. I mean, corruption is a crime, and it's not a crime to join Fianna Fáil. It's certainly misguided, but it's not a crime. You know, you're right in that there is a fixer culture in the party. And it's born out of this thing of identifying the party with the state. You know, I am the state, l'État c'est moi. What's good for the state is good for the party and vice versa. You know, and we have paid a heavy price for that. But to be honest, I believe it was bad decision making. It was negligence. It was dereliction of duty. There was nobody with their hand on the tiller. The regulatory system that was established was defective, didn't work, and nobody was supervising it. Nobody drew attention to the fact the figures were coming in on the screen. They were confidential to government, but government didn't act on it. In 30 years' time, some of you will be writing books about what has happened in the last 2.5, 3 years. It is on a par with what has happened in the early 30s. How much of it you will apportion to corruption and how much of it you will apportion to downright dereliction of duty and inadequacy of regulatory and other provisions, well, history will tell. But I honestly can't say, much as I disagree with some decisions made and the basis for some decisions and the hegemony that I spoke about in my formal remarks, I honestly don't believe that it was corruption in any classic definition of that term. It'll come back, it'll come back, it'll come back. Well, I think it is a valid argument. I think you're right about a higher standard to be expected from the public domain. But, you know, when a firm of auditors sign off on the accounts of a bank and say that everything is healthy and the bank is insolvent, is that any less harmful than a politician who doesn't know his arse from his elbow, but was elected to Parliament? I would have thought that that kind of decision, which has happened so frequently, going back to the Goodman Tribunal, I would have thought that's even more serious. And there's no way that the scandals in our society could have happened without lawyers, accountants, and other professionals facilitating it. And I regard that as every bit as serious, whilst accepting your point that people in public life have a light shone on them that isn't shone on other areas of Irish life.
While you say the responsibility for the small businesses behind individuals, do you not think
You mean individual politicians?
No, I mean, it's like make into a fault of the system, or
In other words, a systemic problem.
Yeah. Well, to be honest, there certainly are systemic problems, you're right. But if you go back over, if we're talking politics, if you go back over the individuals, without name-checking them here, I'm not so sure that it was systemic. I mean, if a politician or if a lawyer is determined to do something to abuse his profession or his office, or is to do something that is corrupt for personal gain or for the gain of someone close to him, they will do it. That is not to say that there aren't urgent reforms of the system that must be put in place. And my point is that it has to go outside of the public domain. I mean, self-regulation of some of the professions, it's not a pretty picture. You simply could not achieve some of the things that have happened in our society unless people, at a minimum, turn a blind eye.
the reality that the civil servants are so powerful, they actually don't have politicians so having power to enforce legislation or to make changes. But the reality is, if you introduce reform, if the civil servants don't follow through with the reform, there's nothing you can do about it to take action. They're too powerful.
Question relates to the power of civil servants, essentially to castrate ministers, essentially, I suppose.
Ouch. Yeah, I mean, if any of you have ever seen Yes Minister, it's a pretty, when Sir Humphrey comes into your office and you, all bushy-tailed new minister with great ideas, and he looks at you and says, that would be a very brave decision, Minister. You're in deep trouble at that stage. I would have thought that, part of the problem is that the Irish civil service has never really been shaken up. We didn't really make many changes when we took over from the neighbouring island. And we still do very many things the same way. And there are fictions that we engage in. Like, for example, you can have some very serious business simmering away, like yesterday and the day before. Somebody asked me, I hear you're taking questions and answers for the government on the Moriarty report. My God, how are you going to do that and all the rest? And I have to say, it was way down my list of priorities. The issues that were preoccupying government over the last 2 or 3 days will be announced by my colleague Michael Noonan in less than an hour. My point being that the issues that are whipped up into a storm in public controversy, are not always the most important issues. And like the man in the audience, I have now forgotten where I was going with that point, but I'm happy that it'll come back to me. What was your question again? Oh, yeah. For example, I was going on to give the example of one hell of a storm can be created in the media and in the Dáil if a letter goes missing and the minister is responsible. And we engage in this fiction. I give you an actual example. When I was last in government in the 90s, Nora Owen, the then Minister for Justice, had responsibility to advise a judge sitting in the criminal court that his, whatever the correct term is, had run out. And the letter went astray. And he continued to sit on the court for some days and make some decisions after his seal of office was spent. And there was war that would have led you to believe that it was Nora Owen's job to dictate the letter, type it, and give it to the postman. Now, that kind of thing is absurd and has gone out with button boots. And constantly, under our law and practice, the minister is supposed to be responsible for the purchase of paper clips and accounting for this and that. The law must modernise and delineate what is the responsibility of the minister and what is the responsibility of Sir Humphrey. And it has to be clear. And executive everyday implementation of decisions should be delegated to Sir Humphrey in a fashion that is easily intelligible and accessible. And the minister is responsible for supervision. The minister, for example, should frequently be held responsible for things that he says he didn't know about, if he ought to have known about them. You know, Micheál Martin cost us an extra couple of $100 million that we need not have paid on the nursing homes issue, but he said he had no responsibility because he didn't read his brief. Now, in that situation, the minister, a minister, should be responsible because they ought to have known. But in the business of implementation of the postal system or something like that, it's ridiculous that we have these phony rows. So we do need to modernise it. It's part of the programme for government that we are committed to revising the 1924 Secretaries and Ministers and Secretaries Act and bring it up into the 21st century.
It was really to do with Fianna Fáil. I know Fianna Fáil ministers say in the past they bought apartments and bought, I know one of the ministers bought 3 or 4 apartments in a block in England, a block in Portsmouth. But when ministers or people are in government, could they be involved in business or involved in stuff like that? Or should there be complete separation? Maybe there is some degree of separation, I'm sure. And if it's built around the issue, is there a value to ministers coming from a business environment, or is there more of a value from them coming from a kind of a purely political career type of thing?
Can I
Would
just
you have views around that?
briefly say that the question relates to sort of the background of ministers, whether they're involved in business backgrounds, and particularly you asked about whether or not they should be involved actively in business transactions during their ministerial office.
Well, they can't be involved in their business, or they can't be a director of their company while serving as a minister. And I think the code of conduct, is quite detailed in that area. I honestly don't know the answer to the question you raise about, where an investment is made by or on behalf of the minister. Whether that is different or not. But certainly, if you were running an insurance company and you're elected to Dáil Éireann, you must resign if you're made a minister. And maybe that should be tightened up and looked at. But I think the actual case you referred to was an investment made by the minister concerned. And I suppose that could give rise to conflict in certain circumstances. But I suppose there might be questions as well about whether you can deprive a citizen of, he's not seeking to do anything other than purchase a property, if you represent North Kerry, you can't drive home every night, and it may be more amenable to if you can afford it, acquire property in Dublin. But there are pretty strict guidelines, in fairness, guiding that.
Got a question here. Can you shut that up? I'm just minding my microphone.
Is the kind of abandonment of responsibility that you were saying for a short-term political gain not corruption? You were saying corruption is rigidly wrong. If you view it in that constitutional way, the government ignored reports from the central bank that their banks are in trouble, that the economy's in trouble. Is that not corruption? Purely based on the fact they don't win the next election. That's benefited themselves. It doesn't have to be a third party.
Yeah.
Involved.
not according to the definition of corruption, and of course that's the point that Dr. Byrne is raising, whether we should have a new definition. Not according to, I mean, it's dereliction of duty, and you have to see it in the context of the times. You know, everybody has an awful lot to answer for when in 30 years' time you are writing the book. You know, for example, this pretends now that we have dozens of people coming out of the woodwork saying, I told you so. Poppycock. You can count them on the fingers of one hand and have some left over. For example, did the media do its job? The answer obviously is no. Did the fact that the property supplements of the broadsheets were larger than the newspapers, did that have anything to do with it? Did the flumery and puffing that went on in the pages of the property supplements, sometimes seeping into the main newspaper, did that have anything to do with it? So, you know, if it's corruption, a lot of people were corrupt. You know, I'd like to stick with the criminal law, and I'd like to stick with legal precepts as I understand them. I'm wary about there are a lot of things wrong with the system, a lot of things that need to be refurbished, but I'm reluctant to put a tag on everyone saying they were corrupt.
I've got 3 people wanting to speak. First I'm going to Dr. Byrne, and then yourself, and yourself. That's 5, so we have to be quick. Lane, sorry, not you. Yeah, just raise your speak loud.
Since I was mentioned, I was just going to say what an absolute can't hear it.
Go and use the main mic, will you? Sorry.
What an absolute honour it is that Pat Rabbitte is the minister in the portfolio that he is. The minister spoke about books that will be written in 30 years' time. Unfortunately, I don't have that luxury. I'm writing the book now, which will be out this year, and it looks not just at this period, but since the foundation of the state. So I tried to sum up the events of the last 20 years in 10,000 words, so wish me luck. But no, what I want to say is, having read through the tribunal reports and read through Irish political history, the one thing that struck out at me was people like Pat Rabbitte, particularly before the Beef Tribunal, when it wasn't very fashionable to be talking about the kind of issues that he's spoken about now. And they were often punished for it, in the sense that they were seen as being people who were awkward and not contributing constructively to public debate and things like that. So I have to say, when the list of ministers arose, I was really personally very delighted, knowing his genuine commitment to some of the issues at heart. And so I just also would like a copy of your speech. So I can study it a little bit further, but I found it very constructive, and just genuine congratulations and thank you, because when I was going through the book, you know, when I search an F and put the word in rabbit, and it just comes up positive the whole way through, and I think it's fantastic that he's in the ministry that he's in, and I actually have a lot of hope and confidence that a lot of the issues that he's spoken about here and the issues he spoke about in previous tribunals will be addressed. And that's not all nice things to say so I can get his speech and find a way to counteract it, but because I genuinely mean it. And thank you very much.
So you're talking about the relationship essentially between elite, in this case builders, and politicians. Yeah. and the cronyism that develops.
Yeah. Well, may I just say this, that prompted by what Elaine Byrne has said, I never thought I would see the day, and I made this point in the Dáil yesterday, where all of the parties in Dáil Éireann have now committed to supporting the bill to ban corporate donations. I never thought I would see the day. And if I can go back to the point that Dr. Byrne made about the Beef Tribunal, very interesting thing about the Beef Tribunal is that if you read it, and you have the luxury of not writing the book just yet, go back and look at it. There is a paragraph in about page 12 from memory that says, in the matter of political donations, because I regard them as normal, I will not be making any findings in that regard. That was the conclusion of Mr. Justice Liam Hamilton. And as a result, that issue, although it was half of the cause for the establishment of the tribunal itself, he deemed that in the climate of the time in which he was living and writing, that they were normal. Now, it is a hell of a new normality, however painful the evolution, that we have come to a situation where it's now normal for the parties to say, I mean, listening to Micheál Martin yesterday and the Dáil, if he met a man with a red nose in Drumcondra, he wouldn't know him. He can't remember him. So there has been a sea change, and it is significant.
I'll take your question there because we're coming to the end. The question relates to if anyone is involved in a tribunal, essentially, should they be prevented by some procedure, legislation, or otherwise from actually running as a candidate? Yeah, running as a candidate.
I got a letter yesterday asking me had I sent in my application for a tax clearance cert. As an example of things that you can do. But I have. That's just one example. I've grave doubts about. I've great doubts about the Dáil deselecting someone who has been elected. I mean, if you don't like Deputy Ming Flanagan's line on cannabis, can the rest of us combine to deselect him because we don't think it's fitting or proper? I'm uneasy. I'm uneasy about that. I'm not sure either that you're going to see too many inquiries in the future based on an act that preceded the life of the state. The 1921 Act is not ideal, as we know, for this purpose. It's certainly very expensive. And, why don't we have a unit in the Garda Síochána equipped with accounting and other forensic skills to which this kind of issue can be referred in the first place? I'm not referring to, an inquiry into the banking crisis, which ought to be done by Parliament itself. But if there is suspected wrongdoing and corruption, why, just like the Criminal Assets Bureau is one division of the Garda Síochána, why isn't there a division, that is equipped to do it, rather than taking 14 years and then sending the results 14 years later? But the business of saying that somebody, is elected to Parliament and the rest of us will vote, I'm personally unhappy and uneasy with that.
Okay, I've got one here, and then we'll have, because it's coming up to 4, so could you be brief?
Yeah, very good. I actually agree with what you were saying last time there in relation to it would be very dangerous precedent, I think, to put people out of Parliament because at the moment it might be popular because Michael Lowry is unpopular. But maybe there should be a mechanism whereby people who are actually caught to be doing illegal things, like in England where they're sent to prison. But I just wanted, there was one question raised by Laura Owen and the issue of the judges sitting on the bench after they're entitled to be a judge. I think the problem here, again, comes back to the political system recognising that there's flaws within the system. Surely, you know, you shouldn't just have to rely on a letter being posted to a judge to notify him of the fact that he's no longer on the bench, because that situation puts in jeopardy serious criminal convictions, and it's the system itself needs to be made very clear and very secure.
All of that is absolutely right, Patricia. All of that is absolutely right. But I don't think that we can ever draw the conclusion that it was Nora Owen's job to make the phone call or to make the, I mean, the system just couldn't work. I mean, for example, we engage in the fiction that the Minister for Justice signs every immigration order. You know, there was a time in Ireland when the only strangers in town here were from Cork. But nowadays, that's not the case. And the proposition that the Minister for Justice is personally responsible for signing every order is ridiculous. And the only place that we have departed from that is in the Department of Social Welfare, where there is an executive arm, and if you have an appeal on social welfare entitlement, it's made to the appeals officer. And there is an executive system within the department that decides, and it's not a matter for the minister. And I think we have to import that into other departments.
I'm going to take this last question, and then, because it is 4 o'clock, and there might be a lecturer outside who's going to... Sorry.
Just very, very quickly, you were saying with regards to how someone speaks to the Dáil on a specific issue and comparing that to the situation that's at hand at the moment. Don't you think...
And comparing that to what?
Comparing that to all of the recent revelations and saying that, you wouldn't be comfortable with the members of the Dáil deciding the future of an elected official. Well, sure, you could actually have the argument there that that elected official was elected before these findings were there. You were saying earlier that someone who's in the Dáil is supposedly at a higher standard. If you were to take the comparison that you made, saying that a private corporation in the Dáil, they should be held to the same standard. Private corporation, something like this comes out, you can't really think that that person is going to stay and hold their position. Surely we should be able to expect from the people that we have elected, they will actually enforce these same kind of moral standards to their own.
Well, firstly, I didn't say that the private corporation and serving in Parliament ought to be held to the same standard. I said to this man that a higher standard must apply if you're in public life. Pardon me?
So then even more so in this situation.
But it's a different matter. It's a different matter to say that you can, by vote, remove someone from Parliament. I mean, the law of the land is there, and a member of Parliament is subject to the law of the land. And therefore, if an offence lies, then prosecute it. But I don't think that you can, I don't think you can leave it to the whim of people in a frenzy at a particular time to exclude someone. I mean, contrary to the kind words that Elaine said about me, there are no plaster saints in politics. And I certainly don't put myself into that category. It's a difficult trade. And, watching yesterday, the leader of the Fianna Fáil party had no difficulty at all relying on Michael Lowry to keep him in office for the last 10 years. And then suddenly he's out of office and he has the opposite view. So, I don't think you can leave it at a whim. Members of Parliament are subject to the law of the land and ought to be treated in the same fashion.
Folks, I'm really grateful to Minister Rabbitte for coming in. We can't go on any longer because many of you have lectures to go to, and also there might be somebody outside there. I'd just like to sincerely thank you for your time at what is a difficult time. Thank you very much.
Thank you.
Was brought to you by Trinity College Dublin. For further information, please visit our website itunes.tcd.ie.